Hi, I'm Ashley Fillippeli. I'm an attorney at Triangle Smart Divorce.
And I'm Katelyn Hodgins. I'm also an attorney at Triangle Smart Divorce. And today we're going to talk about common custody and child support questions in North Carolina. Okay, Ashley, why don't we start by telling them what a custody order is?
Okay, a custody order is a document that's entered by a court. It can be entered by consent of the parties, so by agreement, or it can be entered after a hearing in front of a judge where the judge makes the decision. But it's a legal document that is filed with the court that the judge signs that sets forth legal and physical custody, which we'll talk about, and things like holiday visitation, specifics about communication or extracurricular activities, or really anything else that needs to be addressed about the children. A question we get a lot is, do you have to have a custody order before child support can be determined?
So you actually do not have to have a custody order before child support can be determined. While that is my personal preference, because it makes it a lot easier for the court, you do not have to. However, if there's not one, it's going to be a lot of he said, she said about what is the schedule, who actually has what amount of overnights. So I just think it's a lot cleaner to have a custody order before you're going to do child support.
And we can talk about the connection kind of between custody and child support too, how they interplay with each other. Child support is largely, we go by the North Carolina child support guidelines, and there are different worksheets that you use where you plug in incomes and payments for health insurance expenses, child care costs, work-related child care costs. But the worksheet that you use is dependent on the custody schedule that you have, because worksheet A, for example, is primary custody, worksheet B is shared physical custody, and so you do need to have kind of a working knowledge of what the custody schedule is going to look like, even if you don't have an order in place, to figure out child support so that you know which worksheet to be on.
That's completely right. And it is usually a little easier if that's already been formalized, but they can do it without you actually having done that.
And there are also, at least in Wake County, generally when we file for custody or child support, if we ask for temporary custody or temporary child support, Wake County, they'll go ahead and set a hearing for that. But so that can be a way too, if you don't have everything finalized for permanent custody. If you have a temporary custody order, you can also do a temporary child support order. And then when you figure out permanent custody, you can do permanent child support at that time. What is a temporary custody order?
So a temporary custody order is going to look a lot like a permanent custody order. It might be a little shorter. It is still going to have all the important stuff. It's going to have your physical custody schedule, what we're doing for legal custody, all of those same provisions we talked about when we talked about what a custody order is. The difference is that it is temporary. You can change it. You can change it a lot easier than you can a permanent custody order. And these orders can become permanent by operation of law. The current case law suggests 12 to 18 months. If you're not, doing anything setting permanent custody, that's going to automatically become a permanent order. I personally love to do a temporary order. It gives parents the time to adjust, get on the same page, get into a co-parenting flow. If there are changes, if there are hiccups, you need to alter anything, it's a lot easier to do that with a temporary order.
And also, I think temporary orders are helpful too when if there's a parent who is not able to see their child, like the other parent's withholding the child. A lot of times a temporary order is going to be helpful because you can get in front of a judge quicker to get heard and get the parent who's not seeing the child, get them some visitation time. Or sometimes if there's been alienation for a really long time, you can use the temporary order to kind of ease the parent who hasn't had custody back into a relationship with the child so that they're in a better place once you have a permanent custody hearing.
I also find them helpful when there are substance abuse or mental health concerns, because then we can address those issues, try to get parents who might have those types of issues on the right track, and it's not something they're having to deal with forever in a permanent order.
Yeah. And I think too, one of the biggest differences between a temporary order and a temporary custody hearing and a permanent custody hearing that for an attorney makes a big difference is the time. So like temporary custody hearings, you're limited to 2 hours. That's 1 hour each side. And that goes by so fast.
So
that's
fast.
an hour for me to ask questions of my client introduce exhibits, cross-examine the opposing party, do my opening and closing statements all in that 1 hour, and then the other side has the same. And so I think clients can get frustrated sometimes because there's a lot of information that you just don't have time to get into at a temporary custody hearing. That's more for the permanent custody trial when you can set it for a longer period of time and really get into those specifics of what's going on. But for temporary custody, I mean, the judge, they want to know, does the child have somewhere to sleep? Do they have a room? Are they safe? Big things like, are there drugs involved, or anything like that?
Yeah, it's definitely more of the big overreaching topics. We don't really get down into the tiny little details a lot, and it is just a time thing. We don't usually have the time to get into a lot of things that people want to talk about. They're valid things, but these temporary orders, the way I describe them to clients is they're to some extent meant to be a Band-Aid. You've recently separated or recently come into this conflict, and we're trying to very quickly get some resolution. It might not be the perfect resolution, but it's something, and something is almost always better than nothing. Okay, so there are two different types of custody when we talk about custody: legal custody and physical custody. I will say physical custody is what most people think of when they think of child custody. That's where is the child residing? What is the physical custody schedule? Does one parent have every other weekend? Are we doing a week on, week off? That is what people think of. A lot of people don't understand the difference between legal and physical custody, and that's completely normal.
Legal custody is more who gets to make major decisions regarding the child. So like major decisions like where they're going to school, are they going to have surgery, things like that. And then the parent who has custody generally just makes the day-to-day decisions. So like if the child has a cold and needs to go to the doctor, the parent who has physical custody is going to be the one to do that. But ultimately, legal custody is kind of like, it is whatever it says in the order. I mean, like, you can define legal custody however you want to. You can say that means that we have to talk about these things, but if we disagree, mom's going to have the final say, or dad's going to have the final say, or we're going to refer to a professional. So legal custody is really whatever you say it is in the order. And I will say it's common, I think, for one parent to have primary physical custody and the parties still have joint legal custody.
Exactly, and sometimes I think legal custody is actually the more important part of the order than the physical custody schedule, because who's making the big decisions, what decisions are being made can directly impact your physical custody schedule, so that matters.
A question we get a lot is whether a parent can stop visitation or prevent the child from going to the other parent's house if the other parent is not paying child support like they're supposed to. And the answer is just no. You cannot do that. They are two separate issues. The court treats them as two separate issues. And if the other parent is not paying you child support and you withhold the child in violation of a custody order, that's going to be a problem for you in court. You're not going to get out of it by saying, oh, well, they didn't pay me child support, because the court treats those issues as separately.
Yeah, and there are better ways to enforce a child support order than violating a custody order. If someone stops paying you child support, you immediately need to tell your attorney and have them file a motion for show cause, a motion for contempt, bring this person in front of the judge, have them held accountable for not paying their child support. And that's the proper remedy. Withholding the child isn't going to accomplish anything except probably getting yourself in some trouble too.
Yeah, and to enforcing a child support order, I mean, with child support, when there's a specific amount owed, I mean, it is very common for the judge to say, I'm going to put you in jail, and your purge condition, the way you can get out of jail, is by paying this amount. And it's generally the amount that's owed back in arrears. And astonishingly, people manage to come up with that money
very quickly
before they get taken to jail. So, I mean, that's a quick remedy that, I mean, you have to wait to get a court date and everything, but there's going to be very real consequences if the child support's not paid.
And sometimes, especially if we have repeat offenders in the child support non-payment, sometimes I'll advise clients to go ahead and we can request that these child support payments be automatically withheld from the person's paycheck. Sometimes people just have to be held accountable in different ways, but I usually do wait for someone to be a repeat offender because that process is a little slower. It's slower for our clients to get their child support. It's not ideal for me I don't think it's ideal, but when we have repeat offenders, that's also an option.
What about if the parent violates the custody order?
So we're also going to be bringing this person in front of the judge. We're also going to be filing a motion for show cause, motion for contempt, but it's a little bit different because the punishment is not as easy to get out of.
Yeah.
You had mentioned that if you don't pay your child support, you might be sentenced to jail. You have this dollar amount purge condition where you could get out. Well, for custody, one of the punishments is also jail, but it's happened. You violated it. There's no getting that time back. There's no undoing what has been done. So a lot of times it's just a straight jail sentence or some other punishment that the court deems appropriate. But I've seen many people go and spend some days at the jail for violating a custody order.
And I would say too that, if you're violating a temporary custody order, I always tell my clients, like, we can bring this up at the permanent custody trial, because that's going to help your case at the permanent custody trial if the judge sees that this other party doesn't care about the order or what they're ordering. So a lot of times if it's happening during a temporary custody order, it's better to just wait. Or if it's happening a lot too, you can combine it, even if there's a permanent custody order, you can combine it with a motion to modify and use that as a change of circumstances to say, this is why we need to change the order. One of the change of circumstances, that's not going to be enough probably by itself.
Yeah, I also think that it's important for people to realize a judge doesn't automatically know this is happening. You have to actively take the steps to file and alert the court to the situation. I hear a lot, well, the court's not doing anything, and my first question is, well, did you file the motions that you needed to bring these violations in front of the court? And a lot of times the answer is, well, no, I haven't. So if someone's doing this repeatedly, you have to file something. Typically the behaviors are not gonna just magically go away.
And if it's something, if it's withholding actual physical custody of the child, that's one thing. But a lot of times a violation of a court order is a violation of one of these other provisions about how we go about making decisions or exchanges or anything like that, or communication. And so if it gets to be really bad and it's a really high conflict case, you can appoint a parenting coordinator or a PC, and they're usually an attorney, a family law attorney, and they're neutral, and you can submit disagreements like that, or if there's violations like that, to the PC, and they can issue directives a little bit quicker than getting in front of a court can. But it has to be a really high conflict case and a lot of disagreements on what the order means.
And the best part about those directives, they are just as binding on you as a court order. You can get in trouble for not listening to them. So I also think that a parent coordinator is just a very helpful in high conflict cases, especially in cases where there are repeated violations of those other provisions, not necessarily withholding custody.
Yeah. What if one parent wants to move far away with the child, out of the state or like the other side of the state, where either the current custody schedule is not practicable, or if you don't have a schedule in place, you got to figure out what's going to happen with the child?
Well, so the good thing is that if there is actually a custody order in place and that move is going to completely blow that schedule up, or these parents have joint legal custody and they can't just change the child's school without consent of the other parent, you're going to have to get permission from the court. You're going to have to file a motion to modify custody to try to relocate with your child. In North Carolina, we're very lucky because there's case law, and the court has very specific factors that they look at when they're trying to determine if a relocation's in the minor child's best interest, because best interest is always going to be our golden standard when we're looking at custody. And those factors are pretty clear. The court's going to look at the advantages of the relocation in the terms of its capacity to benefit this minor child, improve their life, the motives of the custodial parent in seeking the move, the likelihood that that parent is going to comply with North Carolina orders. If we're moving out of state and they're no longer subject to this jurisdiction, are they still going to listen to the court here? The integrity of the non-custodial parent resisting the relocation, and the likelihood of a realistic visitation. And those are all great factors, but that only applies when there's a custody order. And we have a lot of people that try to move before custody orders are put in place, and that unfortunately is more of a dicey area.
Yeah, I mean, it's kind of tough to really depends on the situation and the facts of the case, because on the one hand, you don't want to make a judge mad by taking the child out of the state without an agreement, because then they can just order you to come right back, really.
Yeah.
Or to keep the child, at least keep the child in the state until the custody case is decided. At the same time, sometimes if you move with the child, that might help your custody case to go ahead and get things set up there.
Yeah.
And then it's harder to say, oh, well, the child shouldn't move back. So that's something you definitely want to discuss the factors with your attorney. But I will say, when there is a custody order in place and you're doing a relocation case, I always tell clients, like, you got an extra burden to climb.
It's an uphill battle.
It's an uphill battle. It's not going to be just simple, like, not only is it now best interest of the child we got to consider, but still best interest of the child, but also all of these things. So yeah, it's an uphill battle.
Yeah, so I definitely say, if you're thinking about moving, whether you have a custody order or not, don't just do it. Actually talk to an attorney before you make that decision, because they can help you figure out what that would look like. Almost one of the number one things I get asked in consults constantly is, when can my child have a say? When does my kid get to decide where they live? I hear a lot of comments about people who are like, well, I looked it up and the internet said that 12 is when my child gets to decide. That's not true. There is no magic age in North Carolina. Children do not get to just decide where they want to live. Now there are rare cases. I don't like to have children testify. I don't like to have them involved in court cases. I don't think that that's ever going to be in their best interest. But there are circumstances where we have to. The judge might take into account what the child says, but it's not the child's decision. It is still ultimately the judge's decision on what they believe is in the best interest of the child, with all of the evidence. Anything a kid says in chambers on the stand, that's just part of it.
Yeah. And I mean, really the only way to tell a judge what a kid's decision is to have the kid testify. And that's, not only do we not like to do it, but judges don't like it to be done either. I mean, it's very, very rare. So you're not going to have a situation where it's just like, there's no like abuse or like, it's not a very dark situation. It's just high conflict between the parents. The kid's not going to go testify to the judge. No. The judge is not going to want to hear that. And in fact, if you ask, the judge might even
be very angry.
Hold that against you a little bit, because they don't want the kids to be involved in the case. This is between the parents, and the kids don't need to be there. So, and again, like Katelyn said, even if they are there and say, this is where I want to live, the judge doesn't have to listen to them. The judge just has to do what's in the best interest, what they think is in the best interest of the child.
And that can be its own dangerous thing, because then you've brought your child, they've said what they want, and they're not given it. That can sometimes cause some damage.
Yeah. And think about, your children. Like, they're children, so they waffle back and forth, and based on things that are not necessarily in their best interest. Like, they might say they want to go live with dad because dad doesn't make them do chores, but that's not really a reason to go live with dad.
Yeah, and 12, they might be, hey, I want to live with dad. A year later, they've changed their mind. Mm-hmm. They're 100% team mom. That's why we try to keep children out of it, because they do tend to change their mind. They do tend to think one thing one day and another a week later. So letting them make these major decisions is typically not in their best interest.
And kind of on that same subject, just involving your child at all in your custody case is just not a good idea. I mean, obviously there's going to be some things that you have to tell them, because they need to know what the schedule is. They need to know when they're going to be at their mom's house and when they're going to be at their dad's house. But that's pretty much what they need to know. They don't need to know anything else. And judges really don't like when parents involve their kids in the custody case, or talk bad about the other parent or the other parent's family. And, as a parent, you have to think about your child first. You got to put their feelings first and not necessarily your own feelings. But, a lot of times kids who grow up and went through hard divorces, I mean, they struggle later in life. So that's, when you're bringing your kid into this, you're doing something that may have a very long-lasting effect on them. Okay, we talked a little bit about how custody and child support play off of each other earlier, and I brought up the different child support worksheets. So there are 3 different child support worksheets in North Carolina: Worksheet A, Worksheet B, and Worksheet C. Worksheet A and B are generally used. Worksheet C is a parent trap kind of situation where one parent has primary custody of one child and another parent has primary custody of the other child. We don't really see that, so we're just going to talk about Worksheet A and B. So Worksheet A is when it's the primary custody one, but it means that one parent has at least 243 overnights with the child per year. Worksheet B is the shared custody, but it doesn't have to be 50-50 shared custody. It just means that each parent has at least 123 overnights per year, so essentially a third of the year. And if one parent has exactly 123 overnights, you get on Worksheet B, but it has a spot in there where you can put in there how many overnights each parent has. So it does take that into consideration. If one parent, a Worksheet B with a parent having 123 overnights is not going to be the same as a Worksheet B with a parent having 183 overnights or 82, whatever it is.
Yeah, because the worksheets and the overnights matter a lot, because the overnights are directly going to correlate to what is your percentage of, custodial time, what's your percentage of responsibility for the child. So the more overnights you have, usually the lower your child support obligation is going to be.
And generally, just getting from Worksheet A to Worksheet B is usually a pretty dramatic difference in the child support obligation.
Yeah, I would agree with that. So we've talked a lot about child support worksheets, but we haven't really explained when they're used. So anytime someone files for child support, typically that document is going to say, do we want to calculate by the child support guidelines or not on the child support guidelines? Anytime that you are on the child support guidelines, we're going to use one of these worksheets to calculate your child support. How you get off guidelines is you either file to deviate from the guidelines, and that's up to the judge, or if your combined incomes are too high, you're not going to be on the child support guidelines, and we have to actually start looking at reasonable needs and expenses. But if you're on the North Carolina child support guidelines, we're using one of the worksheets, whether it's A, B, or C. We're using your gross income each month. We're going to plug in health insurance if you have any child care expenses, and it's going to give us that magic number of what child support is owed.
I don't have anything to add.
So this process is objectively very expensive. Hiring an attorney is a big financial commitment. So something we get asked a lot is, can a judge order my ex to pay my attorney's fees in these child custody and child support actions?
And the answer is yes, the judge can order that. It is in the judge's discretion, which means that it's not required to be done, but that the judge can do it, and the judge can decide how much to award in attorney's fees. And the statute simply says that to be awarded attorney's fees, you have to bring the action in good faith and have insufficient funds to defray the cost of litigation.
And then when we're talking about a child support action, they also want to see that you haven't been receiving support, and that's why you filed the action. You were not getting sufficient support. And I'll say child support cases are where I see attorney's fees get awarded most commonly because of that extra, hey, I'm not getting child support, I've had to pay money because I wasn't getting money. That's usually where I'm going to see it awarded the most.
Yeah, I think less so. I see it less so in custody cases, although I think you see them more in custody cases, like if there are things going on, like the other party's doing things that are making you incur extra attorney's fees, like being difficult, not being responsive, not like responding to discovery or producing documents. All of those things, I think that can like drive your attorney's bills up. That probably leads more to getting attorney's fees in custody cases.
I would agree. I think if you're filing a bunch of frivolous motions and things that have no purpose except to harass the other party, that's another reason that judges are going to get upset and they're going to award attorney's fees. I also think it's important to note that different judges have different opinions on the issue of attorney's fees. So sometimes who your judge is really can matter on this specific issue.
Yeah.